the scrutiny application. Council submitted that this court has no mandate to grant an amendment of the petition unless it is made within 28 days, that this court cannot bring into effect Section 8D of the Act and Article 159 2D of the Constitution, where it had no mandate in the first place. Council relied on a case of Al-Beiti Hassan Abdallah vs. IEBC. Further, Council submits that the laws relating to EDR, to election dispute resolution, form a complete code for election petition proceedings. They rely on a case of Joseph Tiampati, Musuni, and others, Kantai, which has been referred to earlier on in this same ruling. Council finally submitted that the amended notice of motion is brought pursuant to legal provisions which cannot aid the petitioner, and reiterated the submissions that were similar to those, which were similar to those filed by the first and second respondents' counsel above on this point. Now, having perused and considered the application responses filed as rival submissions of the parties, in my view, the only issue for determination is whether the petitioner or applicant should be allowed to amend his application for scrutiny. This single issue, however, has a number of elements which I'll have to consider hereunder. With regard to whether an interlocutory application can be amended, I note that the intention of the current application for amendment of the notice of motion is to include polling stations for scrutiny. These ones are, several have listed them there. Al-Bajan Primary School 1, I think, Al-Bajan Primary School 2, Al-Bajan Primary School 3, Kwara Adan Awale, Gasser Koluftu, Atibo Hall Market, Kibei Surur, El Kali, Atibo Hall Primary, Baji Mobile, Rift Primary, Jaghir Dam, Boa Primary, Hadado Waberi, Kurman Center. According to the respondents, the DR code only provides for amendment of election petition and not for interlocutory application. Further, they contend that the EDR code is comprehensive, and as such, the provisions of the Civil Procedure Act and rules cannot be imported into EDR matter. This court was referred to a case of Richard Chapi and several other High Court decisions in support of this contention. It is, however, noteworthy that the said decision of Chapi was overruled by the Court of Appeal. That was Koome, Vizram, Koome, as she then was, and Odek. It is to be noted that the applicant in the Richard Chapi case also had applied to the court to reinstate a petition which had been dismissed for want of prosecution. The application was hinged on the Constitution, Civil Procedure Act, and Civil Procedure Rules. In dismissing the application, the High Court made an order that there is no provision under the Election Act which allows for setting aside, review, and/or reinstatement of a dismissed petition. Thus, the decision of the Court of Appeal in that case of Richard Chapi overturned the decision of the High Court. In my view, by allowing the appeal and making the above observation, the Court of Appeal meant that the hands of courts cannot be tied just because the EDR code is deficient in addressing some situations. Thus, there being no specific provisions of law or the rules prohibiting amendment to interlocutory applications for scrutiny, I hold that the court, in appropriate circumstances, can allow an amendments to an application for scrutiny. Each case or request will, however, be considered on the basis of its own peculiar facts and circumstances. With regard to whether the application for amendment herein is time-barred, I note that the case for Gatirau Peter Munya, in that case, the Supreme Court held that any party to an election petition can request for scrutiny at any stage after the filing of a petition and before determination. The present application for amendment was made before closure of evidence tendered in the court by witnesses for the parties. It is obvious from the provisions of the law cited above by all parties that the 28 days bar to amendments relates to the petition, not application for scrutiny. In my view, therefore, since the law provides that an application for scrutiny can be made at any time before final judgment, an application to amend the application for scrutiny can also similarly be made any time before judgment. My above view is buttressed by the fact that Section 82 of the Act also vests the court with discretion on its own motion to make an order for scrutiny. This broad discretion conferred on the court, in my view, meant that the door is not closed for a party to apply for scrutiny or to amend an application for scrutiny at any time before judgment, and the court has similar powers on its own motion to order for scrutiny before judgment, provided that such application or order is in the interest of justice and will not make the petition overflow the statutory period of 6 months and also does not prejudice any of the parties. Having found that the court has jurisdiction to deal with the motion for amendment and the application for scrutiny hearing, for amendment of the application for scrutiny hearing, and that the same is not time-barred, I will now assess whether the listed polling station should actually be included in the scrutiny application. In this regard, Rule 29, 4 of the election petition rules provides that scrutiny should be confined to polling stations in which election results have been disputed. Rule 29.1 provides that the purpose of scrutiny is to establish the validity of votes cast. Having perused the polling stations listed in the amended motion vis-a-vis paragraphs 30, 34, and 51 of the petition, it is clear to me that all the subject polling stations appear in those paragraphs of the petition. In particular, paragraph 31 disputes the validity of votes cast on grounds of vote swapping or vote padding. Paragraph 34 disputes validity on grounds of gross discrepancies in statutory forms, while paragraph 50 disputes validity on grounds of inflation of numbers. Accordingly, and contrary to the submission by the third and fourth respondents, the polling stations in the proposed amendments motion have been pleaded in the petition. My considered view, therefore, is that allowing the amendments motion will not be an expansion of the petition and may thus be included in the list in the application. As to whether allowing the proposed amendments to the scrutiny to the scrutiny notice of motion will be prejudicial to the respondents, I hold that there will be no such prejudice, as parties' counsel will have an opportunity to submit on each of the listed polling stations for the court to determine whether there is justification for an order for scrutiny in that polling station. In addition, as parties' counsel had not filed submissions to the original application for scrutiny by the time the application for amendment was filed, in my view, by their conduct, they chose not to close the door and thus cannot claim now that they will suffer prejudice merely because polling stations complained of in the petition are now sought to be listed in the application, which application is yet to be argued and determined anyway. The final orders of this court are that I allow the application for amendment and order as follows. A, this court grants leave to the petitioner to amend his notice of motion dated 10th October 2022, seeking inter alia scrutiny and recount of the ballot papers and KM's kits in the impaired polling stations mentioned in the application therein. B, that upon granting order 1 above, the draft amended notice of motion application annexed B and is hereby deemed to have been duly filed. The cause of this application are in the cause. Today is when? 16th?
Yes. Then thereafter, my lord.
They are here. Oh, okay.
My lord, I was saying that we require 5 days to put in a substantive response to the amended application, since even there are new polling stations in which we will need to seek more instructions from the client. Thereafter, my lord, we can take directions rather on the filing of submissions by all the parties.
For the third Nura is the third and fourth respondent. My lord, I do agree with the partly with both parties, that is the petitioner and the first and second. Perhaps, my lord, we can have 5 days to respond to the application for scrutiny, now the amended application for scrutiny. And then I would propose that the petitioner would take 3 days to put in any additional affidavit, if need be, together with his submissions. And then we can take 3 days after that. And perhaps, my lord, once those directions are given today, we can calculate those number of days and take a ruling date from that date. These are roughly 10 days. Not mid-February.
Yes, it does. You're asking for 15 days.
It's roughly 10 days.
You see, 12 days for police. 5 days for hours, 5 days for 15 days.
When does it take us?
That's what he said.
Because we are on the 16th.